Good. I had my meeting with Danny. I figured you were on your way. No. You ready? All right. All right, good morning, everybody. We're going to go ahead and take open announcements on the 9 o'clock docket. Just a few ground rules. First of all, we are doing this hybrid. So as always, if you want to appear by Zoom, you can. It's your option. Or if you want to come in here in the courtroom, you can. It's up to you. Same thing with masks. If you want to wear them, wear them. If not, you don't have to. I do require the inmates to wear masks because if you're an attorney that doesn't necessarily want to meet with somebody that doesn't have a mask, that makes sure that you can or cannot. And so if you want them to take it off when they're back there, that's up to you. Other than that, we've tried to put some safety protocols in place, like this hockey glass that we have here, which I can't stand. But it just helps us all be safe and us all feel a little better about it. So we're going to go ahead and take open announcements on the 9 a.m. docket. Mr. Schmidt.
Hey, Jake, Your Honor, Jimmy Marshall.
All right. This is cause number CR 20-0027-173, the state of Texas versus Jimmy Marshall, and this is set today for pretrial. Any pretrial from the state?
Judge, I'm going to have our standard motion for discovery.
No objections.
All right, granted. And on behalf of Mr. Marshall.
Judge, Mr. Cox and I have been discussing this case. This case was originally in the 173rd. And right at the beginning of the pandemic, I filed a motion to reveal confidential informant that Mr. Dickens was handling the case. We had some hearings / discussions with Judge Moore. There were some emails back and forth. He asked us for some email briefs, etc. It was right at the beginning of Zoom, and so it was just a mess. So
right.
I'm trying to recreate.
Still a mess.
Right. I've forwarded some of the emails to Mr. Cox, but we're actually not even sure if Judge Moore ruled, or if there's an actual record of what we submitted other than in people's email boxes. So if we could just reset this for me to continue to kind of try and sort out what happened, I'd appreciate that, just so we know what, if he ruled against me. I know he didn't rule for me, but I don't know if he.
There's only two options.
Well, because I don't know who the CI is, so right. I don't have an order granting it. So, but I just don't know if it. And then it kind of fell off the docket, quite frankly, and so I didn't feel it my job to prosecute my client, so I just fell off the docket.
Understood. Dude, is there anything on the docket sheet? Have y'all checked that? Can I see it?
I have not.
Yeah, it looks like he was arraigned in January last year. No, I'm sorry, February. Says March, just so y'all know, March 3rd, Mr. Schmidt, you appeared with him and they reset pretrial to, I don't know, SC, I don't know what that means, maybe status conference.
Right.
April 22nd, state and defendant appear, attorney present. Pretrial status conference, set hearing. That's all that is on there. Y'all, there's nothing on there.
I think what happened, so there's some emails that says set hearing, and then we were going to get a date, and then the date we had, the investigator was out of town. There were several proposed dates that the state couldn't make their witness available. In the meantime, Judge Moore emailed both Mr. Dickens and I, basically said, what's the issue here? So then he wrote a brief, email brief. I wrote a response brief. And then I remember that we had some discussion over Zoom about it, but I don't know if it was, I think it was like at the tail end of a docket that didn't involve Mr. Marshall. But he said, oh, by the way, I got y'all's emails. There was some discussion. I need to look back. And so that discussion, while maybe on the record, but was not on the date that Mr. Marshall was set.
Gotcha.
So.
Well, I'll do, I mean, I don't mind resetting it. I don't know if we're going to know any more when I do reset it, unless y'all can get Judge Moore to.
And it may just be, we just need to just start over here. Judge.
Refile your motion.
It's, oh yeah, it's on file. So I mean, we may just have to, if
urge
we don't resolve it, we're also talking about.
Okay, well, I'll just do that. I mean, it sounds like we're beating a dead horse now. I just wanted to see where you're at too. So
right.
I'll reset this to April the 15th at 1:30. And if between now and then y'all feel like you need a hearing on a motion to reveal,
Okay,
then just tell Kevin and we can set it for that.
okay.
You understand that, Mr. Marshall?
Yes, sir.
All right, you're free to go, sir.
Thank you, Judge. That's all I have, my big sheet. Thank you.
Ms. Altier,
For pretrial and for trial status.
all right, this is cause number, or these are cause numbers, CR 20-0257 and CR 20-0586-173, both styled the state of Texas versus Christy Kennedy. And let's deal with the 586 case for pretrial first, any pretrial from the state.
Just our standard motion for discovery, Your Honor.
No pretrial, Your Honor.
Do you have any objection to his standard
No, I
motion?
have no
All right,
objection.
granted, no pretrial. And then here's what I'm gonna do. Is she on this trial docket coming up? So she's actually she could be tried this.
Judge, as for this April trial setting, Ms. Altier provided me yesterday with some exculpatory evidence that I need an opportunity to verify and look into. And I'm quite honestly not sure how long that's going to take.
That's correct, Your Honor. We just received some new evidence.
All right, well then I'll just reset both of these I'm just gonna reset them both for status since it's just coming over here for April the 15th at 1:30. The court deems pretrial as held on the new one. However, Ms. Kennedy, and this court, if you're charged with a possession of controlled substance case, order you to take drug tests. So you're gonna go take a drug test today. When you get done, don't leave, come back in the courtroom so we can all go over the results together. So we'll see you back in a little while, but you're reset to April 15th for status.
Can I step down to the results of that?
All right, who we got next? Anybody ready next? Yes, sir. How you doing this morning, Mr. Herrera? All right, these are cause numbers CR 20-0397, 98, 99, 400, 401, 402, 403, and 404-173, all styled the state of Texas versus Arturo Lagunez. I didn't swear the interpreter, I'm sorry. And all set for discovery status. And you solemnly swear to translate from Spanish to English and English to Spanish to the best of your ability. All right, sorry about that. All right, and set for discovery status. Where are we at?
Judge, Mr. Herrera came by our office a few weeks ago, I believe, to go through our file, make sure he has everything. We have subpoenaed Officer Story's medical records. We don't have those back yet. When we do, we'll make them available to Mr. Herrera. Just so that we're all on the same page.
You
in
need
our
medical records from the alleged incident.
Yes.
Okay.
Yes. Just so we're all on the same page. At our next setting, which I believe is going to be pretrial, I do plan on filing a motion to consolidate most of these cases, not all of them, but most of them. Additionally, I anticipate this will probably be a pretty lengthy trial. And so we might need to start talking about a special setting at some point. I'm sure the
April
court-
6th or whatever that day is we have. Oh, we're still waiting on medical records.
Yes, sir. And on my end, I'm waiting on just jail medical records to be produced to us, and that's it.
Jail medical records
Yes, sir.
for your client?
Yes, sir.
How long do we think all that's gonna take?
Not long on Officer Story's medical records, not long.
I think within probably a month or so, I should be able to get those.
Let's do this, which is why we have discovery status. I'll go ahead and set a pretrial for April 15th. And if you don't have all your discovery in, we can deal with it then. I just hate to get to April and say, oh, well, now we have everything. Let's go ahead and set another pretrial date.
Okay,
So we'll set pretrial for April 15th. If y'all need more time, we'll talk about it then.
thank you,
And
Judge.
then maybe then all the discovery will be in. We'll know if we have any pretrial motions. And then we can start looking at the calendar to set this for trial. Because I agree with you. I mean, I signed the warrants on these, so I'm familiar with, at least from the affidavits,
Yes, sir. Thank you,
that
sir.
it will be a lengthy trial.
Will that be at 1:30, Your Honor?
Yes, sir, 1:30.
So April 15th at 1:30? Okay, great. Thank you. Thank you, Judge.
Yes, sir. Good to
Thank
see
you so much.
Other than the excuse.
Yes, ma'am. Good to see you. Feel like I'm in a fishbowl. That's what I'm gonna call it. Being in a fishbowl up here. Mr. Stevens. Uh, Jay.
Wait, what's the other line show? Yeah, they're all.
Which one are we on?
Miss Jello, Your Honor. Jello or J-Lo.
Okay. Krishwana Jello? Jello. Sorry. People call me McGee all the time and I hate it. It's a K, not a G, so I'll try not to get it wrong. All right, these are cause numbers CR 20-0016 and CR 21-0188-173. Both styled the state of Texas versus Krishwana Gello. And let's see, the new case is set for arraignment, Mr. Stevens.
If it may please your court, Your Honor, my client would advise the court that her name is spelled correctly. She understands the nature and consequences of the charges against her. Waive reading of the indictment, enter plea of not guilty.
All right, ma'am, the court notes your plea of not guilty for purposes of arraignment. And so let's move on to pretrial. Any pretrial from the state?
Just our standard motion for discovery, Your Honor.
No objection.
Granted.
No formal pretrial from the defense judge.
Here's what I'll do is the court will deem pretrial held on the 0016 case. On the new case, then we'll set it for discovery status on June the 8th. Oh, we're already talking about June. And then it's like pretrial on July the 12th, both at 1:30. And we'll set both cases for that same day until they catch up with one another.
All right, sir.
Yes, sir. Ms. Moore. Casey Lumpkin. This is cause number CR 20-0553-173, the state of Texas versus Casey Lumpkin, set today for pretrial. Any pretrial from the state?
Just our standard motion for discovery, Your Honor.
I have no objection and I
Granted.
don't have any formal pretrial motion.
All right, well then the court deems pretrial is held. And Mr. Lumpkin, your next court date is for status, and that is April the 15th at 1:30. And that'll be your last day to resolve your case by plea bargain or otherwise, or it ends up on the trial docket. And we are starting jury trials. And we're gonna move pretty quick. Is there an offer? I didn't have to see, you see, have an offer.
We have been negotiating. Yes, there is. There's
And
not.
what is the offer right now?
I think the last one was,
I can't recall off the top of my head.
we were, I want to say 12-month state jail, but he's, Mr. Cox was thinking about some things if Mr. Lumpkin was able to pay restitution, things like
Understood.
that, that we're, in fact, I was gonna try to talk to him today.
I just
about
like to
some-
ask, especially on these 173rd cases, because they're just coming over here. I'm just seeing them and the new office change to make
Yes,
sure that
I have
everybody
spoken-
has an understanding of where the
Mr.
case is.
Cox and I have spoken, and Mr. Lumpkin's ready to make a counter offer that he told me about today. So I'm gonna talk to Mr. Cox
Okay.
about that. So yes.
Fair enough. All right, Mr. Lumpkin, we'll see you back April 15th at 1:30.
And that's all I have this morning, Matthew.
Yes, ma'am. Thank you. Ms. Fallhaber.
Got Jerry Fennell on page 2.
That's fine. You go ahead. If he could step just right over there so she could swear in.
So right here, I think, right? One right.
Where did she, oh, where'd she go? Oh, right there.
Oh,
I
okay,
can't see because of
sorry.
the monitors. You ready? No, hold on, just gotta do just a few minutes. Or a few things. It's okay. I'm not in a hurry this morning. We don't have anything set now. All right. This is cause number CR 20-0345-173, the state of Texas versus Jerry Fennell. And this is set today for a plea. Is the state ready?
State's ready, Your Honor.
And is it Fennell or Fennell?
Fennell.
Fennell, okay. And on behalf of Mr. Fennell,
Ready, Your Honor.
sir, is your name Jerry Neal Fennell?
Yes.
And are you the same person that was originally indicted by Henderson County Grand Jury for the first degree offense of sexual abuse of a child?
Yes.
If I can get you to raise your right hand the best you can, sir. Do you solemnly swear or affirm the testimony you're about to give now on trial will be the truth, the whole truth, and nothing but the truth, so help you God? You can lower your hand. Mr. Fennell, can you read and write the English language?
Yes.
Are you a U.S. citizen?
Yes, sir.
If it turns out you're not a U.S. citizen and you enter into this plea bargain with the state, you could have certain negative immigration consequences. Do you understand that?
Yes, sir.
And Mr. Fennell, have you ever been treated for any mental health or emotional issues?
Depression.
I'm sorry,
Depression.
depression? Are you on any medication for that?
Yes, sir.
And are you taking it as prescribed?
Yes, sir.
And do you understand what's going on in here today?
Yes, sir.
And Ms. Fallhaber, do you believe your client is competent?
I do.
All right, well, Mr. Fennell, even though you told me you've had this diagnosis that and that you're on medication, based upon your demeanor, your answers to my questions and your attorney's statements, the court has no reason not to find you competent. As a matter of fact, the law presumes you competent and I'll find you competent. Mr. Fennell, I know that you've already been arraigned on this case. However, would you like the state to read the indictment out loud
No, sir.
here in the courtroom? But do you understand the charge?
Yes, sir.
Well, as indicted, that charge is a first degree felony. A first degree felony carries a punishment range of not less than 5 years, nor more than 99 years or life. Is this a 25 to life? I'm
Yes,
sorry.
sir.
Based on your charge, it's a kind of a different first degree felony. Actually, the minimum is 25 years. So your punishment range, if you were convicted by a jury or a court, is not less than 25 years, nor more than 99 years or life in the Texas Department of Criminal Justice, and a fine not to exceed $10,000. Do you understand that range of punishment in the plea bargain?
Your Honor, the state recommends 25 years confinement with 594 days credit, $1,250 in attorney's fees, $405 in court fees, and for Mr. Fennell to follow the terms of the lifetime protective order that was agreed to in this case.
Is that your understanding of the plea bargain, Mr. Fennell?
Yes, sir.
Is that your understanding, Ms. Fallhaber?
Yes, Your Honor.
Moment. All right, well, Mr. Fennell, a few minutes ago, you told me you could read and write the English language. I'm gonna go over a couple documents with you. The first, oh, and I didn't ask, is the complaining witness on board with the plea bargain?
She is, Your Honor.
Okay, is she in the courtroom?
No, Your Honor,
Okay, and there's no statement with it?
there is not.
Okay. All right, well, sir, the first document is the agreed plea recommendation. Did you read and go over that with Ms. Fulhaber?
Yes, sir.
Is that your signature on the bottom?
Yes, sir.
Did you read and go over the back with her?
Yes, sir.
And did you sign it?
Yes, sir.
Do you have any questions about it?
No, sir.
The next document I want to refer you to is the court's admonishments and warnings prior to entering a guilty or no contest plea. Did you read and go over both pages of that document with Ms. Fulhaber?
Yes, sir.
And did you sign the bottom of the second page?
Yes, sir.
Do you have any questions about it?
No, sir.
Do you have any questions about any of the documents that you read and went over with Ms. Fulhaber about this plea?
No, sir.
Well, if you read and went over these documents with her, I know she explained to you that you have many constitutional rights, including the right to trial by jury. Do you want a jury trial in this case? Do you want to go forward with the plea bargain in this case?
Yes, sir.
Then I'll ask you, sir, how do you plead to that first-degree felony of sexual abuse of a child under 14 as alleged in the indictment? Are you guilty or not guilty?
Guilty.
And are you pleading guilty because you are guilty and for no other reason?
Yes, sir.
I'll hear the evidence.
Your Honor, the state offers Exhibit 1, copy of the offense report, Exhibit 2, the inventory report, and Exhibit 3, a copy of the lab report. Those documents
Admitted.
fit rest and close. Rest and close.
All right, Mr. Fennell, then based upon your guilty plea and the evidence, the court has enough evidence to find you guilty. Further, the court finds that the complaining witness is on board with the plea bargain. And so the court's going to follow the plea bargain, sentences you to 25 years in the Texas Department of Criminal Justice with credit for 594 days as of today, and orders you to pay your attorney's fees and court costs. And as a condition, you must abide by the agreed lifetime protective order in cause number CV 21-0129-173. Got a couple things to go over with you before you go, Mr. Fennell. Have you had a chance to review the judgment in your case?
Yes.
Is the charge, the time credit, and your name correct?
Yes.
All right, sir. Also, now that you've been convicted of a felony offense, you are now under Texas law ineligible to possess a firearm or ammunition. Those are legal terms. If you have any questions about that, refer to your document in your plea packet and or consult with an attorney. You're now remanded back to the custody of the sheriff for transport to the appropriate authorities to serve out your sentence. Good luck to you, sir. You need to see Mr. Halbert before you go to your right. Mr. Fennell. Miss Kennedy, come on up. All right, we're going to go back on the record in cause number CR 20-0586-173, the state of Texas versus Christy Kennedy. And can I see the docket sheet? Has she been in this court before?
All these cases are, they started.
Oh, they started here?
Yeah.
Huh.
The transfer cases. will be-
Okay. So in February, she was positive. Is that correct? That February?
No. I see a word for UA in February, but I don't see the result.
Yeah, so I'm looking at the docket sheet. She appeared with her attorney, reset for status. Was that today?
I don't think she tested positive the last time, Your Honor.
Did she reset?
That's the right.
That's today. Okay, it looks like a 2 right there. That's why I'm confused.
We got tested her February 4th and she was
And she's positive today.
we had her on Zoom. We had asked her to come in the next day.
And she was negative, but now she's positive, and she is on conditions of bond. Is that correct? Okay. All right, well, it appears as though Miss Kennedy is in conditions of bond. She was asked to drug test today. She's tested positive. The court's going to find her bond insufficient. And what was her bond amount? What is her
Judge,
current bond
on
amount?
CR 2257, it was 25,000.
What about in the drug case? That's the UCW, right?
On the drug case, it's 8,500.
That's correct.
8,500 personal bond, because it was probably a 90-day. I want to find your bond insufficient. I'm setting your bond at $25,000 surety bond on this case.
I have nothing further to do. You have excused.
Yes, ma'am. If y'all want to work something out, I'll be here all morning. Yes, sir. Mr. Castleberry.
Morgan. He's now on about page, I'm not on page one anymore. Someone's on
I
page-
can't hear you. Who is that?
It's a
You'll
Christopher
just, you
Morgan.
don't have to whisper. If you'll just speak up, I can hear you. It's just people that talk low, I can't hear.
I've got my hearing aids turned all the way up,
Okay.
and so that causes me to talk low, but I'll adjust.
All right, Christopher Morgan. Come over here, sir. There you go. All right, this is cause number CR 21-0153-173, the state of Texas versus Christopher Morgan. And that is set for a plea today, but he hasn't been arraigned. Is that correct?
You were right.
No.
It says arraignment / plea, so let's go ahead and arraign him first.
Mr. Morgan, we've received a copy of the indictment, right? Yeah, I went over it with you. You understand what you're charged with, what the range of punishment is. And so for the purpose of the arraignment, you're pleading not guilty. That's right. He's arraigned. He's pleading not guilty for purposes of arraignment.
All right, well, then the court notes his plea of not guilty for purposes of arraignment, and it says set for a plea today, but I don't have any paperwork.
Well, there's a reason for that, Judge.
Your Honor, there is a bit of a snag. Mr. Morgan's mom is in stage 3 cancer, and she's gone into some special treatment. They posted bond for him in the hopes that you would give him a reset for his plea, not to undo the plea, but to reset the plea date so that he can help her attend to this treatment. And she is here today if you would like some
don't-
testimony
I
from
mean,
her.
a state and agreement.
Judge, my issue with this is I think it's akin to people that are in custody. They come before the court and they ask for a month before they enter their plea and turn themselves into TDC, and then they don't come back. We dealt with this yesterday.
Well, but yesterday was somebody that already pled guilty. He's still presumed innocent. That's the issue I have. He's presumed innocent. He hasn't pled to anything. I mean, all we have is y'all have an agreement to plea, but if the agreement doesn't include a particular day,
I'm ready for the plea today. If the court wants to give him a reset, I understand.
it's not up to me. I can't order, I guess I could reset his plea, or I could order him to plea today, but I wouldn't feel comfortable ordering somebody to enter into a plea bargain to the position it puts the court in.
I understand.
Because I just accepted his plea of not guilty. Now, what that can mean, Mr. Morgan, is really the ball's not in my court, the ball's in the state's court, because they can withdraw your plea offer. I don't know whether they will or not, but I can't order you to plead guilty today.
Tell you what. Let me talk to Mr. Castleberry real quick.
Okay.
Your Honor.
I'll recall it. Mr. Weiner.
Yes, last page.
I said I'd recall it.
And then the state's gonna agree to the reset.
He's gonna do
We're
waiver
gonna do
jury.
a jury waiver and the state will agree to the reset.
Well, I think you probably need to admonish him on that before why don't you talk to him and tell him what that could mean? Because if he waives a jury and the state pulls the offer. Yeah, I'm just gonna recall it. You need to go admonish him on a jury waiver. Mr. Weiner.
Take a food drive, last page.
Got your masks, Judge. Masks.
Yeah, I know.
Yeah.
And that's, if you get back there and the attorney wants to talk to them about it, that's on them. Like a fishbowl. I feel like I'm in a fishbowl. That's how I just figured it out. I'm gonna have to take this stuff down.
It's like you should cash checks,
I'm not doing that.
lottery tickets.
No, not in here. You ready? Sorry, Mr. Boudreau. All right, this cause numbers CR 20-0085 and 0594-173. And both of these are styled in the state of Texas versus Jacob Boudreau. And both set for discovery status. Where are we at?
Your Honor, I believe we've received everything from the state. So we have nothing to request, ready to move forward for the pretrial setting.
That's correct, Judge.
Okay. All right, well, then the court deems discovery status is held. And Mr. Boudreau, your next court date is April the 15th at 1:30 for pretrial.
That's all I have. Maybe excuse Judge.
Yes, sir.
Maybe excuse as well, Judge.
Yes, sir.
Thank you.
See you later. You just keep watching.
I'm sorry.
I said, you just keep watching.
Oh, my goodness. It's really inhibiting my sleep. I can't stop.
I can tell you were up late.
Oh, yeah. Yeah. Have a good one.
Mr. Stevens. All righty, this is cause number CR 19-0314-392, the state of Texas versus Scott McDowell. And this is set for announcement for trial beginning with voir dire on April the 9th at 8 a.m. at the Texan Theater. Let's say the state.
Your Honor, state's ready.
And on behalf of Mr. McDowell,
Your Honor, we are ready. There's, my understanding, there's 2 discs that they're still trying to get from Caney City. I don't anticipate that would be any major snafu. Those either exist or they don't exist, but other than that issue, we are ready, Your Honor.
okay. All right, well then, this is the first one, right? Or no, it's the second one? The
This is
first
week
one.
1, right? This is week 1.
Okay. All right, well then, it's like both sides are ready. And so we will see Mr. McDowell at 8 a.m. on April the 9th at the Texan for jury selection. However, I do have a capious profile. Have you seen that, Mr. Stevens, for him?
No, sir, I haven't.
All right, you want to see it? Looks like it's for $1,231. Might want to go with your client, but I'm going to have to ask him to have a seat in the jury box. It's a warrant.
Yes, sir, I'll visit with them on that. Yeah, looks like a misdemeanor case. I'll visit with you on a second on that. What's the date for the jury or the actual trial? Are we gonna jury select and then go straight into trial, or are we
No.
doing trial at a later date?
It's the 19th, I think, for guilt.
But you had all this stuff committed to memory. Haven't had a jury trial in a year and some months. You don't even know. You know when each turn vacation, you don't know when we're going to trial.
I remember vacation.
Supposed-
So voir dire will be on the 9th at Texas, and then trial will start Monday, the 19th.
Okay.
I don't know if we really decided 8:30, 9 o'clock.
8:30.
Hey, Judge, we're also ready on Mr. Garrett, Jamie Garrett, for a plea.
This is the case with the victim impact statement.
Start. All righty, this is cause number CR 20-0152-392, state of Texas versus Jamie Garrett, set for jury trial announcement. However, a plea has been presented to the court. Is state ready?
We're ready, Your Honor.
And on behalf of the defendant,
We're ready.
sir, is your name Jamie Lee Garrett? And I'm gonna need you to speak a little louder than that.
Yes, sir.
All right, and are you the same person that was originally indicted by a Henderson County grand jury for the second-degree felony offense of burglary of a habitation?
Yes, sir.
I can get you to raise your right hand, sir. You solemnly swear or affirm the testimony you're about to give now on trial will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir.
And you can lower your hand. Put that document in here. All right. Mr. Garrett, can you read and write the English language?
Yes, sir.
Are you a U.S. citizen?
Yes, sir.
If it turns out you're not a U.S. citizen and you enter into this plea bargain with the state, it could have certain negative immigration consequences. Do you understand that?
Yes, sir.
And Mr. Garrett, have you ever been treated for any mental health or emotional issues?
No, sir. No, sir.
You had to think about that. You haven't?
No,
All
sir.
right. Do you understand what's going on in here today?
Yes, sir.
And Mr. Stevens, do you believe your client is competent?
I do, Your Honor.
And the court's going to find that he is competent. Mr. Garrett, I know that you've already been arraigned on this case. However, would you like the prosecutor to read the indictment against you out loud here in the courtroom?
No, sir.
But do you understand the charge?
Yes, sir.
Well, as indicted, that charge is a second-degree felony. A second-degree felony carries a punishment range of not less than 2 years, nor more than 20 years in the Texas Department of Criminal Justice, and a fine not to exceed $10,000. Do you understand the range of punishment?
Yes, sir.
And the plea bargain?
Your Honor, it's 8 years confinement in TDC with credit for 478 days served. The defendant's going to be responsible for attorney's fees, court costs, and restitution to Allstate and Mary's Win.
Is that your understand? And well, let me ask you, is the complaining witness on board with the plea bargain?
Yes, Your Honor.
Okay. Is that your understanding of the plea bargain, Mr. Garrett?
Yes, sir.
Is that your understanding, Mr. Stevens?
It is, Your Honor.
Mr. Garrett, a few minutes ago, you told the court you could read and write the English language. I'm going to show you 2 documents here. The first is the agreed plea recommendation. Did you read and go over that document with Mr. Stevens?
Yes, sir.
Is that your signature there on the bottom?
Yes, sir.
Did you read and also go over the back?
Yes, sir.
Is that your signature there on the back?
Yes, sir.
Do you have any questions about it?
Yes, sir.
The next document I'm going to refer you to is the court's admonishments and warnings prior to entering a guilty or no contest plea. Did you read and go over both of those and sign the second page with Mr. Stevens?
Yes, sir.
Do you have any questions about it?
No, sir.
Do you have any questions about any of the documents you read and went over related to this plea?
No, sir.
Well, if you read and went over these with Mr. Stevens, I know that he explained to you that you have many constitutional rights, including the right to trial by jury. Do you want a jury trial?
No, sir.
You want to go on with this plea bargain?
Yes, sir.
Then I'll ask you, sir, how do you plead to that second-degree felony offense of burglary of a habitation as alleged in the indictment? Guilty or not guilty?
Yes, sir.
And are you pleading guilty because you are guilty and for no other reason?
Yes, sir.
I'll hear the evidence.
Your Honor, I have states 1 an offense report and states 2 is Michael Morton compliance.
No objection.
I think we're going to start putting them through there so they don't rub across the microphone. You say no objection.
No objection.
Admitted.
State rests and closes.
Rest and close as well.
All right, Mr. Garrett, based upon your guilty plea and the evidence, the court has enough evidence to find you guilty and does find you guilty of that second-degree felony offense of burglary of a habitation. The court notes that the victim is on board with the plea bargain. Therefore, the court accepts the plea bargain, will follow it, sentences you to 8 years confinement in the Texas Department of Criminal Justice with credit for 478 days. You got it. Orders you to pay your attorney's fees and court costs in restitution in the amount of $10,611.48. Before you go, Mr. Garrett, a couple more things I need to go over with you. First of all, have you had an opportunity to review the judgment of conviction in your case?
Yes, sir.
Is your name, the charge, and the time credit correct?
Yes, sir.
Next, sir, now that you've been found guilty of this felony offense, you are now under Texas law ineligible to possess a firearm or ammunition. If you have any questions about what that means, refer to the packet in your plea, refer to the document in your plea packet or consult with an attorney. And sir, before I'll let you go permanently, do we have a victim impact statement?
There is, Your Honor.
All right, and who is it that's going to be providing that? And they could step forward right here just to the end of the entrance of the well. Or they can come over there. But you could come through. And ma'am, and your name is?
Mary Jeanette Lynn.
Okay, and are you the victim in this case?
Yes, sir.
All right, ma'am, go ahead. The floor is yours.
Nice to see you in the daylight, Mr. Garrett. I have a statement, Your Honor, and I'd like to read that statement.
Yes,
Mr.
ma'am.
Garrett and to the court.
Yes, ma'am, go ahead.
Mr. Garrett, I know you. I don't know you. However, unfortunately, I do know of you. Let me introduce myself to you. I'm a retired, single, 66-year-old woman who has a hearing loss which requires me to wear hearing aids. I remove these aids at night before I go to sleep. I sleep with the fan on to drown out noise due to the ringing in my ears associated with my hearing loss. I have sleep apnea as well, so I sleep with the CPAP machine. The noise of the machine is masked by my fan. I do not hear well without my hearing aid. I'm also the owner of a loyal rescue dog named Buddy. Buddy and I live together. The early morning, approximately 3:30 a.m., and also the morning after Thanksgiving 2019, I was suddenly awakened by my dog, Buddy's furious barking at my bedroom door. I went to the bedroom door and looked out on my back porch and saw the shotgun he left outside by my other back door adjacent to my living room. When I went to my living room to check the shotgun, I found my back door wide open. I had both locks on the door. I had locked both locks on the door prior to retiring for bed that night or that morning, and then saw the door shut to my office bedroom really behind. Buddy ran to the closed door, continued barking. I grabbed my .357 Smith & Wesson pistol and called the police. While waiting on the police to arrive, I cocked my gun and waited for you to open the bedroom door. And I prayed to my higher power that if I did have to shoot you to protect myself or my dog, that I would only injure you instead of killing you. My higher power answered. My gun went off accidentally and blew holes through my refrigerator cabinet, back door, and outside grill, all with one bullet. I trust you were grateful that I missed you. About 2 seconds after you were shot, you broke into my office bedroom. You broke my office bedroom window and like a chicken, escaped through the window with several of my personal items, leaving the damage behind for me to deal with. I did deal for pretty much with the physical damages and the items you stole from me. My insurance covered part of my losses, except for the approximately $3,000, which I paid to the insurance company, not to mention the rise of my insurance rates, because I filed a claim courtesy of your uninvited intrusion earlier, thanks to anyone for both of us. But I continue to deal as best I can with the emotional damage you also left behind. I no longer feel safe at night, much less when I go to bed, wondering when you are coming back. I check my doors several times before retiring to bed, then get up and check them again, something I've never done. I worry about mine and Buddy's safety, and now sleep with that same .357 at the ready. I wake up several times tonight wondering if you are outside your door, and frequently check the jail roster to make sure we're still contained and not terrorizing someone else in the community like you terrorized me. This poor decision on your part has changed not only your life, but mine as well. Our actions, good or bad, always affect others. We both, unfortunately, now reap the consequences of your decision and your actions. My life will never be the peaceful, serene life I worked so hard to attain. I urge you during your extended stay with the state of Texas to reevaluate your life. Consider your future life plan and take advantage of the additional support services offered to you by the law-abiding taxpayers of the state of Texas. Yes, these people are affected as well by financial pain from your incarceration. And finally, in forgiveness of your fatal decision and actions that you made, I'll plead your case to my higher power and ask that when you have demonstrated that you have learned the lesson, that you will be given a second chance.
Yes, ma'am. Thank you, Ms. Flynn. Mr. Garrett, you're now remanded to the custody of the sheriff for transport to the appropriate authorities to serve out your sentence.
Gonna have one more we're working on.
Your Honor, are you still taking open announcements?
Well, I try to clear out the courtroom first. I still have Mr. Castleberry here. That way we have as little people in the courtroom. Are you ready on something, Mr. Castleberry? Yeah, let me grab those and then I'll get to you.
No problem, Your Honor. I thought I saw everybody leave yet.
This is the jury
This
waiver.
is the waiver of jury.
Hold on a second.
Mr. Cox requested.
Be excited.
Your Honor, we're just asking for a 45-day reset for a plea, Your Honor. And I believe Mr. Cox is acquiescing in that.
Well, let me go back on the record. CR 21-0153-173, the state of Texas versus Christopher Morgan. The parties took a recess after Mr. Morgan was arraigned. Apparently there was a plea offer on the table. Mr. Morgan was supposed to plea today, but other arrangements have been made. The court has been presented with a waiver of jury. And Mr. Morgan, if I can get you to raise your right hand, please. Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth to help you God? Yes, sir. You can lower your hand. Mr. Morgan, I know that you sat down with Mr. Castleberry and went over this. Do you understand that?
Yes, sir.
All right. And Mr. Morgan, you understand that the Constitution of both the United States and Texas guarantee you a trial by jury if you're an accused in a criminal case. Right? No one but you, with consent of the state, can waive that right.
Yes, sir.
In other words, you're the only one that can assert it. They just have to agree to it. You understand that?
Yes, sir.
But you don't have to do this. Do you understand that?
I understand.
And so I hope you understand that by executing this waiver of jury, that you are no longer guaranteed that right, because, well, if I find that you knowingly, voluntarily, and intelligently waived it, that if I do that, if I find that, then if you decide not to do this plea bargain, or for some reason the state, and I don't know what deal y'all have, decides to yank the plea bargain, then you're stuck with a bench trial. You understand that? In other words, trial before the court. Do you want a jury trial?
No, I'm fine.
You want to waive this jury trial? You understand all of the implications of that?
Yes, sir.
And Mr. Castleberry, do you believe your client waived his jury trial or his right to trial by jury intelligently, knowingly, and voluntarily?
I do, Your Honor.
And the court's going to find that he did and has signed it. And so when are we resetting this for a plea?
May 12th.
May 12th, 1:30. All right, Mr. Morgan, we'll see you back May 12th, 1:30.
Yes, sir.
All right, now, Mr. Cargill, I think you were, let me get you pinned here. You got me, Mr. Cargill?
Yes, Your Honor. My client's present. in Zoom. Jedediah Reed. Yes.
Mr. Reed, do you have video?
Yes.
All right, I got you. All right, these are cause numbers CR 20-0360, 0361, and 0362-173, all styled the state of Texas versus Jedediah Reed, and all set for pretrial. Any pretrial from the state?
This is standard motion for discovery on all three cases, Your Honor.
Right. Any objection?
No, Your Honor.
All right, granted. And any pretrial on behalf of Mr. Reed?
Your Honor, we don't have any pretrial today. I will
Today is pretrial.
state that we have we received new discovery on Monday, a statement, and we may be asking to file a motion to suppress on that statement, but we just received it Monday. We had to come pick it up because it wasn't enough. It was too large to deliver on electronic delivery.
I understand. All right, well then, I'll go ahead and deem pretrial held, but I'll grant you leave to file any additional pretrial motions based on the late discovery. And so I'll set this for April the 15th for status, but again, if you need something, Mr. Cargill, just get with Kevin and he can set a date on a pretrial motion.
Thank
All right, and then Mr. Reed, we'll see you back April 15th, 1:30. If we do have to have a contested pretrial motion, I'm going to need everyone in the courtroom.
Yes, Your Honor.
Okay,
Yes, sir.
all right. Thank y'all. Y'all are free to log off. And Mr. Green?
Ready, Judge.
All right, and we have first is Melvin Keel.
Should be in custody, Judge.
I got him. All right, this is cause number, or these are cause number CR 20-0503 and 0504-173, both styled the state of Texas versus Melvin Keel, and both set for discovery status. Where are we at?
Your Honor, we have shared all the discovery. Most recently, a lab report was shared on March 18th, and that should be everything in this case that we have in possession. We have also provided an offer back in October that was 30 years on the 0503 case to consider the 0504 case, and that was pending victim approval.
Yeah, Mr. Green?
Judge, I would just ask Ms. Pace if what was shared on the 18th was the same exam.
Can y'all
We were
both
waiting
shift
on.
over about 3 steps this way? Shift over 3 steps to your right, my left. 1, 2, 3. There we go. Now we got everybody in the shot.
That should have been the lab report.
So I know we've been waiting on a SANE report.
Let me look.
And I was not, it was sometime early last week, the last time I was on the portal. For some reason, I don't get notified when stuff gets loaded, so I have to check it on my own.
I'll look when I get back to my desk and let you know for sure, but I have that it's a lab report.
Okay. I guess, Judge, depending on what's there, whether or not I need to file any pretrial.
That's why we have discovery status, so
Yeah.
we can kind of figure it out. So here's what I'm gonna do. I'll set pretrial for April 15th at 1:30, and just like I did with Mr. Cargill, I'll give you I'll deem discovery status is held, but I'll allow you leave a court to file late pretrial based upon late discovery.
Thank you, Judge.
Same thing if you need you need to file any other motions, just let Kevin know.
Yes, sir.
All righty. All right. Thank you, sir. You can have a seat there, Mr. Keel. Thank you. Next is Stephen LeBlanc. And again, if I can get y'all shipped over so you're in the camera view, that way Mr. Green can see everybody. You know, I'm gonna be a TV producer when I'm done here. I think it's pretty good. Maybe we ought to put some masking tape on the floor so people know where to stand. Okay. All right, this is cause number CR 20-0567-173, the state of Texas versus Stephen LeBlanc, and set for pretrial. Any pretrial from the state?
Just a standard motion for discovery, Your Honor.
Judge, I don't have any objections to that.
Granted, and on behalf of Mr. LeBlanc,
Judge, I need to ask the court set pretrial on Mr. LeBlanc. I was appointed on February the 3rd to replace Ann Thompson. On that date, I requested discovery. Didn't get it. Again, I sent an email on March the 11th indicating that I'd requested it on February the 3rd and that I had not received it. And last week I finally did receive it, but I have not had it. And I told Mr. LeBlanc that I would visit with him once I'd gotten discovery and had a chance to review it. And though I have it, I have not had a chance to review it, and certainly haven't had a chance to discuss it with Mr. LeBlanc.
That's correct, Your Honor. We turned that over recently, but we also have discs that are ready for Mr. Green to pick up in his case.
then what I'll do is reset pretrial to April 15th at 1:30. You okay with that, Mr. LeBlanc?
Sure.
All right, then we will reset pretrial for April 15th at 1:30. You can have a seat, sir. Next, we have Davion Wilson. All right, Mr. Wilson, I'm going to call your case. It's cause number CR 18-0185-173, the state of Texas versus Davion Wilson, set for pretrial. Any pretrial from the state?
Just a motion for discovery, Your Honor.
Any objection?
No objections, Judge.
Granted, and on behalf of Mr. Wilson,
Judge, same problem as Mr. LeBlanc. I was appointed back on December the 9th, requested discovery that day. Didn't receive anything. I requested it again on January the 13th. Finally received written discovery through the portal. When I've reviewed it, noticed that it referred that made reference to Athens Police Department interviewing several witnesses, that there were no written statements by those witnesses. So I only assumed that those interviews were done by video. Also, there was a reference that a video was seized from a convenience store that allegedly shows Mr. Wilson in that video. I requested those videos on February the 2nd, and as of today, I have not received anything or noticed that there were any videos ready for pickup.
let's say the state. If you can step over just a little bit so you can see, if you look up there, Danny, you step over this way.
Where am I? Oh.
That camera right there. Now
Okay,
we can see you.
gotcha. Can you see me now, Steve?
Yes, sir.
I'm gonna personally look into that, Your Honor. Have we discussed this?
We have not, Mr. Cox.
Okay,
We've talked about a bunch, but we have not talked about this one.
okay, I'll take care of it personally.
All right, then I'll reset this to April 15th at 1:30. Mr. Wilson, you're all right with that? All right, well then we'll see you back April 15th at 1:30. You can have a seat, sir. Thank you.
Thank you, Mr. Cox.
Got anything else, Mr. Green?
That's it, Judge. May I be excused?
Yes, sir. Appreciate you.
Thank you.
I think we're going to go ahead and take about a 15-minute recess. It's 10 o'clock. We've been going a good solid hour. So, and I think we don't have anybody else ready anyway. So take about a 15-minute recess and we'll be back. Y'all let me know when you got something. that. Mr. Head.
Your Honor, Tracy Huddleston.
Huddleston. What are we doing?
Your Honor, we've got an arraignment on
Okay.
his latest case, so I think what we're going to do is go ahead and arraign him on that. Reset that one. I think we're fairly close to hopefully getting something worked out. If we could get a new setting on all those together, hopefully we'll have a resolution at the next setting.
Okay, then I'll call them. These are CR 20-0026, 0111, 0601-173, and then cause number CR 21-0098-173. And all of those are styled the state of Texas versus Tracy Huddleston. And so on that 21 case, let's go ahead and arraign him, Mr. Head.
Your Honor, I have gone over the indictment with Mr. Huddleston. His name appears correctly. He understands the nature of the charge. We waive the formal reading of the indictment, and our plea is not guilty for purposes of arraignment.
All right, sir, the court notes your plea of not guilty for purposes of arraignment. And then so I think, Mr. Head, I think you were telling me we're just going to reset this for June 8th. And then that's the next day, right? So I'll reset the new case and all the old ones back to June the 8th at 1:30 for discovery status. And then again on July the 12th at 1:30 for pretrial, and we'll just run them all together. And if y'all work something out before then, just get with Kevin and we can get it on the docket.
Yes, sir.
You understand all that, Mr. Huddleston? You got that? Okay, we'll see you back in June, if not sooner.
Your Honor, Jacob Mormon.
Okay. Jacob Mormon. All right, this is CR 19-0263-392, the state of Texas versus Jacob Mormon. And this is set for announcement for trial with voir dire beginning April 16th at 8 a.m. What say the state? State's ready.
Your Honor, we're ready, but we have reached an agreement that would wrap up not only his felony, but he has a couple of pending misdemeanors out of this same episode that we feel like we need to get 1245 letters from the county attorney's office. And this was a new agreement so we don't have paperwork on that today.
Okay.
I think if we could bring him back over sometime before the 29th or on the 29th, we could get it resolved at that time.
You got space? For plea?
That, I guess that'd really be up to the state to get the paperwork together. I think I can get the TIC letters quickly.
Yeah, I think we could do it. I can set it tomorrow afternoon. Or
Sure.
we can go next week. I've got some.
Judge, probably the sooner the better, just so that we can get it.
Fair enough.
resolved.
I can set it for tomorrow at 1:30.
That we agree with that?
Yes, Your
All
Honor.
right, so I'll set these for a plea tomorrow at 1:30. Mr. Mormon, you all right with that? All right, that's what we'll do then. Next, we have Mr. Moyer. Come on up, sir. These are cause numbers CR 20-0111, CR 20-0211, 0212, and 0213-392. All style of the state of Texas versus Jerry Moyer, and these are set for announcement for trial with voir dire beginning April 16th at 8 a.m. Do we have any agreement on this?
Your Honor, we do.
Okay.
If we have an agreement on the burglary of the habitation charge, the other two charges, the state needs to confer with the complaining witnesses on those, but we anticipate that we'll either have a set plea or an open plea on those cases.
Well, I mean, if it's public servant, I imagine they can't be too hard to get a hold of.
No, that'd be. I just didn't want to plead them today without talking.
No, I got you. You want to do it tomorrow afternoon? Same thing?
If you can be ready, we should be able to be ready. It's,
Okay. Well, then, Mr. Moyer, you're all right with that? Set it tomorrow afternoon? All right, let's set it tomorrow afternoon at 1:30.
Thank you.
No, I mean, I'll rush y'all, but
No, you're good.
we got a lot of cases we got to move, and I just hate to set up for, if we're all in agreement and we can get it done, let's get it done.
If I could do it now, I would. But
I understand.
yes, sir. That's all I had, Your Honor. If I could.
Yes, sir. Appreciate you.
thank you, Judge.
You're welcome. Mr. Stevens.
Gotta be a plea.
Okay.
There are a couple of motions to withdraw that we filed,
Are you-
so put that on the record. We'll remove those with my client's agreement.
All right, these are cause number CR 20-0076 and see, CR 20-0571 -173, both styled state of Texas versus Danny Robinson. Set for pretrial and a motion to withdraw as counsel in each case today. And so I think we need to deal with that motion to withdraw as counsel. Mr. Stevens.
Thank you, Your Honor. If I may briefly call my client with regards to that.
Okay. Mr. Robinson, if you can raise your right hand the best you can. You solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir.
You can lower your hand. Go ahead, Mr. Stevens. See, I can hear him. Something about certain voices I can hear. Go ahead.
Please state your name for the record.
Danny Robinson.
And Mr. Robinson, I've been representing you for quite some time now. Is that correct?
Yes, sir.
In fact, we've gone through two different prosecutors since I've been handling your case. Is that
Yes,
correct?
sir. That's correct.
And throughout the course of this case, there have been several different offers made and negotiations, and ultimately, we thought we got to a point where some of the negotiations broke down and there was some animosity between you and me for a period of time. Is that correct?
Yes, sir.
You had requested that I file a motion to withdraw, which I had filed on your behalf. However, once we got to court today, this is the first time we've been able to come to court in person. Is that correct?
Yes, sir.
In quite a while since COVID, correct?
Yes, sir.
And we were able to continue some open negotiations and ultimately we reached a plea agreement here today.
That's correct.
And are you asking that I rescind those motions to withdraw that I previously filed?
Yes, sir. I did.
And you're asking that I continue to represent you as your attorney and complete these plea bargains? Is that
That
correct?
I do. That's correct.
And obviously, since we had some animosity, are you now completely satisfied with my representation?
Completely satisfied.
Your Honor, we'd ask to withdraw those motions to rescind those motions to withdraw and ask to proceed forward with the proposed plea recommendations in this case.
Okay. All right,
Your Honor,
then.
if I could make a statement,
Well, it's not the way it works. Do you,
that's fine. That's-
if
we're
you,
good.
if your attorney wants to ask, if you want to ask, he's got anything to say?
No, we're good. We're good.
Let me just sign this stuff since there's two. I'm missing a signature on this one, Dan.
Sorry, Judge.
From the state. Just get all my paperwork straight. That way we can get through it pretty quick. But it's just more and more paperwork every year. Every legislative session.
I just came across a new document. We're now, this restitution sheet we're now signing that goes to
Yeah, there's a
TBC.
bunch.
That's the first I've seen of that document.
Well, I think that was the DA's office wanted to do that because it protects their victims.
Gotcha.
All right, I've already called him and so a plea has now been presented to the court. Is the state ready?
We're ready, Your Honor.
And on behalf of Mr. Robinson,
We're ready.
all right, and the court notes that Mr. Robinson has asked his attorney to withdraw his motions to withdraw. And the court then allows those motions to be withdrawn without a hearing. And so, sir, is your name Danny Kalen Robinson?
Yes, Your Honor.
And are you the same person that was originally indicted by a Henderson County grand jury in each of these cases? In 0571, the state jail felony possession of controlled substance charge, and then again in 0076 to the third degree felony possession of a controlled substance charge. Are you that same person?
Yes, Your Honor.
If I get you to raise your right hand, sir. He's already under oath. You don't, well, it's the plea. Go ahead. You solemnly swear or affirm that the testimony you're about to give now on trial will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, Your Honor.
To lower your hand. Mr. Robinson, can you read and write the English language?
Yes, sir.
Are you a U.S. citizen?
Yes, sir.
If it turns out you're not a U.S. citizen and you enter into this plea bargain with the state, it could have certain negative immigration consequences. Do you understand that?
Yes, sir.
And Mr. Robinson, have you ever been treated for any mental health or emotional issues?
No, sir.
You understand what's going on in here?
Yes, sir.
And Mr. Stevens, do you believe your client is competent?
I do, Your Honor.
And the court finds that he is competent. Mr. Robinson, I know that we've already arraigned you on these two cases. However, would you like the prosecutor to read the indictments against you out loud here in our courtroom?
No, sir.
But do you understand those charges?
Yes, sir.
Well, as indicted, that state jail felony case in 0571, it's a state jail felony, and the punishment range for that is not less than 180 days nor more than 2 years in a state jail felony facility. However, it's my understanding that the state has alleged 2 enhancement paragraphs, which would make that a third-degree felony. A third-degree felony carries a punishment range of not less than 2 years or more than 10 years in the Texas Department of Criminal Justice, and a fine not to exceed $10,000. And in this 0076 case, as indicted without any enhancement paragraphs, that's also a third-degree felony with the same punishment range. Do you understand those punishment ranges?
Yes, sir, I do.
And the plea bargain in the case or the
Your Honor,
cases?
Your Honor, CR 2076 173, 2 years confinement, TBC, credit for 384 days served. Cost of life restitution. CR 2571 173 is 9 months confinement in the state jail felony facility, credit for 384 days. Plus attorney's fees, court costs, and life restitution, and these two sentences are the run concurrently.
And it's you're just abandoning one enhancement paragraph?
In 76, Your Honor?
Or 571? Is it just says the defendant plead, oh, he's going to plead true to the first, but not the second? Because that wouldn't do anything to the punishment range.
On 571, Your Honor, both enhancements are to be abandoned. To make that a state jail.
Let me just look at the indictment. Yeah, because it's kind of, it says abandoned paragraph 1, but that would be enhancement paragraph. That makes me think that it was charged in 2 separate theories. So you're abandoning both of them.
Yes.
I'm going to just change that. I'm just going to strike abandon both enhancement paragraphs. All right. And so just so I can sum this up, in 571, abandoning both enhancement paragraphs, 9 months state jail with credit for 384 days. 0076, straight third degree, 2 years, credit for 384.
Yes, sir.
Is that your understanding, Mr. Robinson?
Yes, sir.
Is that your understanding, Mr. Stevens?
Yes, sir.
Well, Mr. Robinson, a few minutes ago, I asked if you could read and write the English language. You told me you could. Is that correct?
Yes, Your Honor.
Holding in my hand 2 documents, the agreed plea recommendations, just one for each case. Did you go over each of these with Mr. Stevens?
Yes, Your Honor.
And did you sign it there on the bottom?
Yes, sir.
And on the back, one for each case, did you sign the back of both of those?
Yes, sir.
Do you have any questions about it?
No, sir.
The next document I want to refer you to is the court's admonishments and warnings prior to entering a guilty or no contest plea. There's actually 2 of these documents. They say the same thing, but there's one for each case. Did you go over that with Mr. Stevens?
Yes, sir.
And did you sign the bottom there on the second page?
Yes, sir.
Do you have any questions about it?
No, sir.
Do you have any questions about any of the documents that you read and went over with Mr. Stevens related to this plea?
No, sir.
Is that a no?
No.
All right. Well, if you read and went over these with Mr. Stevens, I know he explained to you that you have many constitutional rights, including the right to trial by jury in each of these cases. Do you want a jury trial in any of these cases?
No, sir.
Do you want to enter into the plea bargains in each of these cases?
Yes, sir.
Then I'll ask you, sir, in CR 20-0076-173, as to that third degree felony offense as alleged in the indictment, Are you guilty or not guilty?
Guilty.
And are you pleading guilty because you are guilty and for no other reason?
Yes, sir.
And in cause number CR 20-0571-173, to that state jail felony offense as alleged in the indictment, are you guilty or not guilty?
Guilty, Your Honor.
And are you pleading guilty because you are guilty and for no other reason?
Yes, sir.
I'll hear the evidence in each case.
From CR 2076, I have 3 exhibits. Stage 1 is an office report. Stage 2 is Michael Morgan compliance, and stage 3 is a lab report.
No objection.
Admitted.
State will rest and close in that clause. In CR 2571, I have 3 exhibits as well. Stage 1 offense report, stage 2 Michael Morgan compliance, and stage 3 lab report.
No objection.
Admitted.
State rests and closes.
We'll rest and close on both cause numbers as well.
All right, then, Mr. Robinson, based upon your guilty plea and the evidence in that 0076 case, the court has enough evidence to find you guilty and does find you guilty of that felony offense as alleged in the indictment. The court follows the plea bargain, sentences you to 2 years in the Texas Department of Criminal Justice. You have 384 days credit and orders you to pay your court costs and lab fee. In this case will run concurrent the CR 20-0571-173. And in that case, based upon your guilty plea and the evidence, the court has enough evidence to find you guilty and does find you guilty of that state jail felony offense. The court follows the plea bargain, sentences you to 9 months in state jail with 384 days credit and orders you to pay your attorney's fees and court costs as well as the lab fee. And this will run concurrent with the 0076 case. And so, Mr. Robinson, before you go, there's a couple more things to go over with you. In each of these cases, there is a judgment. Did you review this judgment with your attorney?
Yes, sir.
Is your name, the charge, and the time credit correct in each one?
Yes, sir.
And finally, sir, now that you've been convicted of these felony offenses, you are now under Texas law ineligible to possess a firearm or ammunition. If you have any questions, there's a document in your plea packet, or you can consult with an attorney. All right, you're now remanded back to the custody of the sheriff for transport to the appropriate authorities to serve out your sentence. Good luck to you, sir.
Thank
See Mr. Halbert to your right.
Your Honor, that will conclude my business. May I be excused?
Yes, sir.
Thank you,
Appreciate
Judge.
it. Is that everybody? Is that everything? We done? Oh, I didn't go through my docket to see. Work real fast, but we kind of moved a pretty good pace. It's 29 in the last 2 days. Oh, let me get off.